If your son or daughter's name is on your home deed right now, stop what you're doing. Because a tax rule that expires in 2026 could force your child to pay double the capital gains taxes when they eventually sell that house. And most families have no idea this is coming. In the next 8 minutes, I'm going to show you exactly what's happening, why it matters, and what you can do about it before the window closes. Let's start with why people do this in the first place. Because the intention is completely reasonable. You've worked hard your whole life to pay off that home. Maybe it's worth $350,000. Maybe it's worth $600,000. And you want to make sure it passes to your kids without them having to go through probate court, without lawyers, without delays. So someone, maybe a friend, maybe a well-meaning neighbor, tells you, just add your kid to the deed. Simple, clean, done. And honestly, for years, that advice wasn't terrible. But here's what most people don't understand. The moment you put your child's name on that deed, you have just made a legal gift. And that gift comes with serious tax consequences that could cost your family tens of thousands of dollars down the road. The key issue is something called the cost basis. And that's the number the IRS uses to calculate how much profit your child made when the house is eventually sold. Let me break down cost basis in plain English, because this is the heart of the whole issue. Let's say you bought your home in 1995 for $120,000. That $120,000 is your cost basis. It's what you paid. Today, that same home is worth $420,000. If you sold it yourself, the IRS would look at the difference, $300,000 in profit, and potentially tax you on that gain. Now, here's where the tax code has actually been very generous to families for decades. When you pass away and leave your home to your child through your will or through a trust, your child receives what's called a stepped-up basis. That means the IRS resets the cost basis to whatever the home is worth on the day you die. So if the home is worth $420,000 when you pass, your child's basis becomes $420,000. If they turn around and sell it for $430,000, they only owe taxes on $10,000 of gain. That is a massive tax break. We're talking potentially $40,000 to $80,000 in taxes they would never have to pay. But here is the critical part. When you add your child to the deed while you're alive, they do not get the stepped-up basis on your share. They inherit your original cost, your 1995 price of $120,000. And that changes everything. Let me show you exactly what this looks like in real money, because the difference is staggering. Same house, same family, two different outcomes. Scenario 1. You leave the home through your will or a living trust. Your child inherits it, gets the stepped-up basis at $420,000, sells it 2 years later for $450,000. Their taxable gain is just $30,000. At the long-term capital gains rate, they might owe around $4,500 in federal taxes. Scenario 2. You added your child to the deed 10 years ago. They inherit your original cost basis of $120,000. They sell the house for $450,000. Their taxable gain is now $330,000. And their federal capital gains tax bill? Somewhere between $49,000 and $66,000, depending on their income. Same house, same sale price. But because of how the deed was titled, your child could owe $60,000 more in taxes. That is not a technicality. That is real money that was supposed to stay in your family. Now let's talk about why 2026 specifically is such an important deadline. Right now, many of the provisions from the 2017 Tax Cuts and Jobs Act are still in effect. These include relatively favorable capital gains rates and elevated estate tax exemptions, currently over $13 million per individual. But many of these provisions are scheduled to sunset at the end of 2025. When 2026 arrives, unless Congress acts, the estate tax exemption drops roughly in half, back to around $7 million per person. For most of you watching, the estate tax itself may not apply. But what Congress does or does not do with capital gains rules, stepped-up basis, and property transfer taxation is genuinely uncertain. There have been serious legislative proposals in recent years that would have eliminated or limited the stepped-up basis entirely. None of them passed yet. But the risk is real, and the window to restructure how your home is titled is right now, while the rules are still favorable. Waiting until 2026 to think about this is waiting too long. Many people watching this right now are going to realize their child's name is already on the deed. And the first thing I want to say is, don't panic. This is fixable in most cases. The most common solution is to remove your child from the deed now while you're still alive and healthy. This is done through a simple deed transfer, a quitclaim deed, or a warranty deed, depending on your state. Your child signs their interest back to you. Yes, there could be gift tax reporting involved, but in most cases, there is no actual gift tax owed, because the lifetime federal gift tax exemption is currently over $12 million. Your estate attorney or real estate attorney can walk you through this in an afternoon. The second option many families use is a revocable living trust. You transfer the home into the trust. You remain in full control of the property during your lifetime. You can sell it, refinance it, live in it. Nothing changes for you. But when you pass, the home transfers to your child through the trust, completely outside of probate, and they receive the full stepped-up basis. It is the best of both worlds. Easy transfer without probate, and maximum tax protection for your family. If setting up a full revocable living trust feels like too much right now, I understand. There are simpler alternatives worth knowing about. One option is called a transfer on death deed, sometimes called a beneficiary deed. It's available in about 30 states. With a TOD deed, you record a simple document that says, "When I die, this property transfers to my child automatically. No probate, no trust." And because the transfer only happens at death, your child still receives the stepped-up basis. It can cost as little as $200 to set up with an attorney. Another option is a life estate deed. You keep what's called the life estate, meaning you have the legal right to live in the home and control it for the rest of your life. Your child holds the remainder interest. When you pass, the home transfers automatically. In most cases, the stepped-up basis still applies to the majority of the property's value. Every state has different rules, so please, do not use a template you found online and do this yourself. A 1-hour consultation with a local estate planning attorney could save your family more money than almost any other conversation you have this year. Let me bring this all together with something concrete you can do in the next 7 days. First, pull out your home deed, or look it up through your county recorder's office online, and check whose names are on it. If your child's name is there, that's your starting point. Second, call a local estate planning attorney, not a financial advisor, not a tax preparer. An attorney who specializes in estate planning or real estate law. Ask them specifically about the stepped-up basis rules and what your best option is, given your state and your situation. Third, don't wait for Congress to figure out 2026. The strategies that protect your family are available right now. They are legal, and they are not complicated. Many people worry about running out of money in retirement. But I've seen just as many families lose significant wealth not because they ran out of money, but because they didn't take the time to structure things properly. Your home is likely your largest asset. The way it's titled could be the most important financial decision your family makes this decade. If this video helped you see your situation more clearly, share it with someone you love, a sibling, a friend, anyone who might have their child's name on a deed without realizing what it could cost. And if you have questions about estate planning, Social Security timing, or making your retirement savings last, browse the other videos on this channel. Everything here is designed to help you make confident, informed decisions. So the wealth you've built over a lifetime actually reaches the people you care about most.